The day I watched a man worth hundreds of millions of dollars discover that money cannot buy justice was one of the most defining moments of my career on the bench. If this is your first time here, hit that follow button now so you never miss a story like this one. Before we go any further, I want to say something important. This is a dramatized story inspired by real courtroom lessons about law, responsibility, and fairness. The names, the company, the location, and all events described are entirely fictional. They exist to illustrate a moral truth, not to represent any real person, organization, or legal record. What I am about to share is a legal story built on principles, not facts from any actual case. Now let me take you into my courtroom. Years before the case I am about to describe, I had a moment that shaped the way I think about justice. A young man stood before me in the Lakewood County Courthouse charged with theft. He had stolen food from a corner store, not a television, not jewelry, food. When I asked him why, he kept his eyes on the floor and told me quietly that his daughter had not eaten in 2 days. The law is the law, and I honored it, but I sentenced him to community service rather than jail time, and I connected him with resources in Riverton City that could help stabilize his family. That was the day I understood something important. Compassion and accountability are not opposites. They belong in the same courtroom. They belong in every verdict. That understanding traveled with me through every case I have taken since, and it was sitting right beside me the morning Marcus Hale walked through my courtroom door. Marcus Hale was the founder and chief executive officer of a company called Crestline Digital Solutions, one of the most well-known technology firms in the Riverton City region. He had donated to public campaigns. He had a performing arts center with his name on the entrance. His company employed more than 400 people. And when he walked into my courtroom that Tuesday morning, he walked in the way some powerful people do when they have never truly been told no. He was unhurried. He was polished. He looked around the room like a man attending something slightly beneath his attention. He wore a suit that likely cost more than most people in that room earned in a month, and he had brought 3 attorneys with him. 3. His lead counsel was a man named Gerald Price, known throughout the county for taking difficult cases and winning them with precision and confidence. Gerald Price sat down at the defense table and opened his briefcase like he was preparing for a routine afternoon meeting. Marcus sat beside him with a small, settled smile on his face, the kind of smile that says the outcome has already been arranged. Across the aisle sat Clara Mendez. Clara was 38 years old. She had worked as a software quality engineer at Crestline Digital Solutions for 9 years. 9 years of positive performance reviews, 9 years of dedication. She had given that company a significant portion of her professional life. She sat at the plaintiff's table with a single attorney, a thoughtful and prepared woman named Jennifer Adler, and Clara looked tired in a way that had nothing to do with sleep. It was the kind of tired that builds when you have been fighting an uphill battle against someone with far more resources, and you are still not sure whether truth will be enough. If this story is already resonating with you, share it with someone who believes the law should protect everyone equally, not just those with the deepest pockets. The case before me involved 2 serious claims. The first was wrongful termination. The second was corporate negligence. Clara alleged that she had discovered a dangerous flaw in one of Crestline's flagship products, a health monitoring application used by patients in dozens of medical facilities across the region. The app was designed to track and display critical patient data in real time. Clara's testing revealed that under certain conditions, the application misread that data in ways that could put patients at serious risk. She had reported the problem through every proper internal channel available to her. She had documented everything. She had sent her concerns to her direct supervisor, then to the vice president of product development, and finally, after receiving no meaningful response from either, she had emailed Marcus Hale directly, multiple times, with red receipts. 8 months after her first report, Clara was let go. Crestline's stated reason was company restructuring. Gerald Price presented the defense with the polished ease of someone who had done this hundreds of times. He laid out spreadsheets showing broader company cost reductions. He introduced a list of other employees terminated during the same period. He characterized Clara's safety concerns as, and I remember this phrase clearly, unsubstantiated technical complaints from a mid-level employee with no executive authority. He reminded the jury about the hundreds of jobs Crestline had created in the community, the charitable contributions, the economic value the company brought to Riverton City. He was not aggressive, he was smooth, and that smoothness was its own kind of pressure. I kept my expression neutral on the bench. That is simply what judges do. But I was listening to every word, and I was watching the room very carefully. Jennifer Adler was methodical in a way I appreciated. She did not perform, she built. She walked the jury through a precise timeline, document by document, email by email. She showed the read receipts on Clara's messages to Marcus Hale. She showed that Marcus had opened each one. She showed that not a single one had received a reply. She asked the jury to think about what that silence meant. Not the silence of a man who did not receive the message, the silence of a man who chose not to respond. Marcus leaned over at one point and said something quietly to Gerald Price, and then he smiled. That same calm, settled smile, as though none of what Jennifer was presenting could reach him. Stay with me through the final verdict, because what happens next in this courtroom drama is something I have thought about ever since. Then Jennifer Adler said 4 quiet words that changed the temperature in that room entirely. Your Honor, Exhibit 14. She placed a document on the projector screen. It was an internal assessment report commissioned by Crestline Digital Solutions itself, prepared by an outside consulting firm, dated 18 months before Clara was fired. The report had never been made public. And in clear professional language, it identified the exact application flaw that Clara had been reporting internally. It went further than Clara had gone. It described the risk level as moderate to serious in medical environments, and it recommended immediate corrective action. The courtroom went completely silent, not the polite quiet of people listening, a real, deep silence. The kind where you become aware of the hum of the ventilation system above the ceiling. Nobody moved. Several jurors had been writing and stopped mid-sentence. I watched Marcus Hale's smile disappear for the first time since he had entered my courtroom. His jaw shifted. His eyes went to Gerald Price. He had not simply ignored Clara. He had ignored a professional report his own company had paid for, which confirmed everything she had been saying. Gerald Price recovered and objected on procedural grounds, arguing the document had not been properly disclosed during the discovery phase. That is the process before a trial where both sides share their evidence with each other. I reviewed the objection carefully. Jennifer Adler responded that the document had been submitted within the required legal timeline and that the defense team had received their copy 42 days before the trial began. I reviewed the record. She was correct. The exhibit remained on the screen, and then something happened that no one in that courtroom expected. A man in the gallery stood up. He was in his mid-50s. He wore a plain jacket. He had not been on any witness list for either side. His name was Thomas Breen, and he had worked as a senior in-house attorney at Crestline Digital Solutions for 3 years before resigning quietly 2 years prior. He had come to the courthouse that day as a member of the public. He had no official role in the proceedings. But when he saw Exhibit 14 projected on that screen, something moved in him. He walked to the gallery railing and asked my bailiff to pass a handwritten note to the bench. I received the note. I read it once, and then I read it again. I called an immediate recess. In my chambers, with both legal teams present, Thomas Breen told us that he had direct personal knowledge of a second internal assessment, one that went further than the first and identified the product flaw in even more specific clinical terms. He told us that he had personally witnessed Marcus Hale review that second report and instruct his legal team to ensure it was never included in any company filing, any regulatory submission, or any document that could become part of a legal record. Thomas had resigned because he was unwilling to participate in that decision. He had stayed silent afterward because of a non-disclosure agreement he had signed at the time of his departure. But he had spent the previous evening with his own personal attorney after he learned the trial was beginning, and he had been advised that what he witnessed constituted a deliberate effort to mislead the court. That kind of conduct, he was told, can void the legal protections of a non-disclosure agreement. And so he had come to the courthouse that morning not knowing whether he would speak. He had made the decision to stand up when he saw the screen. If you believe that people who stand up for what is right deserve to be heard, follow this channel and keep this community growing. When we returned to the courtroom, everything had shifted. Marcus Hale was no longer leaning back in his chair with that settled confidence. He was sitting very straight, his jaw tight, speaking rapidly and quietly into Gerald Price's ear. Gerald Price was listening without expression, but his pen was no longer moving. The ease was gone. I allowed Thomas Breen to be sworn in as a witness. These situations are uncommon, but the law gives a judge the ability to respond when something of potential significance to the court's understanding of truth comes forward in this manner. I proceeded carefully as the law requires. When Jennifer Adler asked Thomas directly whether Marcus Hale had known about the second report and had directed that it be concealed from legal and regulatory proceedings, Thomas looked across the courtroom at Marcus for a long, steady moment. Then he said, in a voice that was completely calm and completely clear, "Yes, he knew. I was in the room," he said, and these are the words I remember. "Make sure this one never sees daylight." The courtroom went silent again. This silence was different from the first one. The first silence had been shock. This one was heavier. It was the silence of a room full of people watching accountability arrive, not with noise, not with drama, but with the slow and undeniable weight of truth spoken plainly in a public space. Clara Mendez pressed her hand gently over her mouth. She was not crying. Her eyes were steady. But I could see in her face what 9 years of doing the right thing and then losing everything for it feels like when the truth finally lands in the open. Gerald Price requested a recess to confer with his client. I granted 15 minutes. When Marcus Hale returned to his seat, the suit was the same. The man wearing it was different. The confidence was gone. In its place was the look I have seen on people in that chair before. The look of someone calculating exactly how much this is going to cost, and realizing for the first time that the number is not something money can simply be handed over to fix. I have seen that look before. It always arrives later than it should. Before you hear my verdict, drop a comment and tell me, at this moment, what do you think justice looks like for Clara? Let me tell you how I thought through this before I spoke. A verdict, when it is done properly, is not a reaction. It is a decision that holds 4 things in balance at the same time. The law itself, accountability for the harm caused, compassion for the full human reality of everyone involved, and protection of the broader community. On the law, the case was not ambiguous. The evidence of wrongful termination was substantial and documented. The existence of suppressed safety assessments created serious legal liability that extended well beyond the original employment dispute. These were not close questions. On accountability, the record showed a pattern. Clara had reported a safety concern. It had been confirmed by outside professionals the company had hired. A second, more serious assessment had been ordered, and then that assessment had been deliberately hidden. Clara had lost her job during that same period. Accountability in this case was not about punishing one person's arrogance. It was about making clear that when a company's decisions expose people to harm and then silence the person who tried to stop it, there must be consequences. Without consequences, nothing changes. On compassion, I thought about Marcus Hale as a person. He had built something real. He had created jobs. Somewhere in his history, he had made decisions that helped people. The law does not ask me to destroy a person. It asks me to hold a person responsible. Those are different things. Compassion in a courtroom is not softness toward wrongdoing. It is the refusal to treat any human being as though they are nothing more than the worst thing they have done. And on protecting the community, I thought about the patients using that health monitoring application. I thought about the medical professionals relying on it to make decisions. I thought about the 400 employees of Crestline whose futures were now affected by choices made at the top of the organization. And I thought about what message this verdict would send about whether the law in Lakewood County meant what it said. I ruled in favor of Clara Mendez on the wrongful termination claim. I awarded her full compensation for all wages lost from the date of her termination, plus additional damages for the professional and personal harm caused by that wrongful decision. I referred the matter of the suppressed safety assessments to the appropriate regulatory authorities for investigation into potential fraud and public safety violations. I ordered Kreslin Digital Solutions to establish, at its own expense, an independent safety review board to examine all of its health-related products within 90 days, with quarterly reporting requirements to the court. And I imposed a significant punitive financial penalty against the company, calibrated not to destroy it and the livelihoods of its employees, but to make the cost of suppressing safety information higher than the cost of acting on it. I looked at Marcus Hale as I finished reading the ruling. He was very still, not angry, not tearful, just still. I have no way of knowing what was happening inside that stillness, but I believe that sometimes a verdict does something that arguments cannot. It makes a moment real in a way that changes something in a person. I hope that was true for him. Justice served through the law is not meant to end a person. It is meant to redirect them. Clara Mendez let out a long, slow breath when I finished. Jennifer Adler placed a hand on her shoulder, and Clara nodded once. There was no celebration, no cheering, just that quiet exhale that belongs to someone who held on through something very hard and made it to the other side. Thomas Breen sat in the gallery with his hands folded in his lap, looking at the floor. He had done something difficult. He knew that the days ahead would bring complications, but he had stood up in a room full of people and told the truth, and you cannot take that back once it is given. Near the back of the room, I noticed two young employees from Crestline who had come to observe the trial. They could not have been more than a few years out of college. They did not look relieved or satisfied. They looked the way people look when something they trusted turns out to be something different from what they thought it was. I felt for them. Their leader had failed them too, in a way that had nothing to do with them personally. I hoped they would take something useful from the day, something about what kind of professional they wanted to become. Now, before I leave you, I want to share the thought that has stayed with me long after this case ended. The law is not a luxury for people with money and time. It is a structure built to protect every person, including the ones who walk into a courtroom with one attorney, tired eyes, and nothing but the truth on their side. This legal story, as I said at the beginning, is fictional. The characters are invented. The company does not exist. But the principles at the center of it are as real as anything I have encountered in my years on the bench. Power without accountability is a hazard to everyone around it. Wealth does not make anyone more right, and it does not make anyone more deserving of protection than the person standing across the room. And compassion is not something that belongs only to defendants who seem sympathetic. It belongs in every decision for every person in the room because that is what it means to take the law seriously. I have spent my career believing that a courtroom, when it functions the way it should, is one of the most honest places in a community, not because it is perfect, not because every outcome is clean or satisfying, but because in that room, the rules apply to everyone. A verdict is not the end of a story. It is a moment of clarity. What people choose to do after that moment is their own. I hope you leave this story thinking a little more carefully about what fairness costs and who pays for it when it is ignored. I hope you think about the people in your own life who told the truth and were made to feel small for it. And I hope you carry with you the understanding that justice served with wisdom and compassion is not just a legal outcome. It is something worth protecting every day, in every choice you make. That is all from my courtroom today. I will see you in the next one.